and co-commissioners. Apologies for forgetting to honor the standing arrangement.
No problem.
Chair, before we start with the witness, and for purposes of locating her evidence within the terms of reference, might I ask perhaps to first, by way of outline, touch briefly on some of the terms of reference? We know that in terms of the terms of reference, the Commission shall inquire into, report on, and make findings and recommendations concerning. Then I'm reading from 1, and I'm going to read 1.1 of the terms of reference. Whether criminal syndicates, including but not limited to drug cartels, have infiltrated or exert undue influence over the South African Police Service, including the Political Killings Task Team and Crime Intelligence. Then I skip to the second term of reference, and there I'm going to read read with 2.2. The nature, extent, and consequences of such infiltration or influence, including the suppression or manipulation of investigations. Then 5 and 6, the effectiveness or failure of oversight mechanisms and the adequacy of current legislation, policies, and institutional arrangements in preventing such infiltration.
The latter being 6.
Yes. Thank you. And the next witness, Major General Van Rooyen, is going to testify in respect of the legislative prescripts and in an endeavor to assist the Commission in answering part of those questions.
May I immediately tender an apology, General? I addressed you as Ms. Apologies.
No.
Absolutely no need to apologize, Chair.
Thank you. General Mukwana, you told us that regardless of what comes before the General, whether Major General, Lieutenant General, the mode of address is General. Thank you, General.
Thank you. I hope by the end of the hearing, I'll also be referred to as General Motau. Ma'am, if I can then perhaps also, before we start with the questions, Chair, I appear together with my learned friend, Advocate Lee Segal Ngube, and I should also acknowledge one of the team members who was crucial in the preparation of this aspect of the work, who was unable to be with us this morning, Advocate Ufenze Mutlasedi. Thank you. So the engine room did its part, I should do mine. General, in front of you, there are 2 files. There's one smaller file, which is file 1, and there's one bigger file, which is file 2. And Chair and co-commissioners, I don't know whether for purposes of the record, do we follow that sequence? Is it Van Rooyen 1 and Van Rooyen 2?
Yes, please.
Thank you, as the Commission pleases. If I can ask you to go to file 1, Van Rooyen 1. Do you confirm that that is your statement? And if you turn to page 46 thereof, is that your signature that appears on that page?
That is correct, sir.
Thank you. Then if I can ask you to turn back to paragraph 1. You state that you are a Major General in the South African Police Service and that you hold a doctorate degree in law. Is that correct?
That is correct, sir.
How long have you been with SAPS?
Close to 42 years of service.
Purely out of interest, doctorates in law may be a PhD, which I've seen mostly with the Rhodes University. Most usually have LLDs. So it may be a PhD or an LLD. What is yours?
Chair, I've got an LLD.
Thank you.
For reasons that we won't go into, the chair's knowledge in this area is something we don't need to dwell into. And also the choice of the institution that is referred to.
Mr. Matau, my interest is in what field, specific field of law is the LLD?
Criminal law, sir.
Thank you, Chair and co-commissioners. General, in paragraph 4...
Sorry, if I may just add, I've got a master's, a LLM in constitutional law and or fundamental rights and constitutional practice. Just for the record, while we're sharing secrets.
Thank you, General. In paragraph 4, you deal with the co-functions of the position that you occupy. If I can just ask you to take the commission through those.
My core functions as the head of governance, legislation and policy, that is in the division legal services, is to oversee the governance, legislation and policy service within the police. It involves the management of legislative and regulatory functions, to ensure the legal vetting of new and revised policies in the police, and to provide legal support on advocacy functions, as well as to manage and utilize human, financial, physical and information resources in accordance with the strategies, priorities and regulatory framework of the police.
What exactly do you mean by vetting policies?
Chair, that would be, for example, if there's new national instructions relating to an operational or a support function, the policy owner, for example, visible policing, will be the compiler of the document, the national instruction, and then it is forwarded to us for legal vetting to ensure that it complies with the law, that it's not in conflict with any other prescript in the police, and to also make a recommendation for the National Commissioner on the approval thereof.
General, what is advocacy functions for the SAPS?
Commissioner, that relates specifically to new developments in law, court judgments and the implications thereof on the police, and specifically relating to judgments and where we can improve our regulatory framework.
And just before you go to the next section, General, who do you report to?
I report to the Divisional Commissioner Legal Services, and we are part of the support services, the Deputy National Commissioner. In other words, that would be either General Nkwa or General Tampane, and thereafter the National Commissioner.
Thank you. In paragraph 5, you state that you made the statement for purposes of giving evidence at the commission, and it is at the invitation of the commission. Is that correct?
That is correct.
And then in paragraph 6, you outline the themes that your statement covers or deals with. And it is clear from there, you firstly highlight the constitutional and statutory framework regulating SAPS. You provide a legal overview of the applicable legislation and policies regulating the SAPS. You also provide a detailed analysis of oversight mechanisms that regulate SAPS. you proceed to then deal with the disbandment of the PKTT by the minister, and you provide your view on whether the conduct accords with the statutory framework set out in your statement, and you conclude by making some general observations on legal aspects that have been raised and identify potential deficiencies in respect of the oversight mechanisms. Is that correct?
That is correct, sir.
Yes. Then if I can ask you to deal with the first topic, which is SAPS constitutional and statutory overview. You deal with that commencing from paragraph 7. Yes, if I can ask you to deal with that.
Okay. In this section, I explained that the workings of the police with reference to the relevant portions of a constitution and legislation and regulation of a service. Section 199 of the Constitution regulates the establishment, structuring and conduct of a security services, a single defence force, a single police service and any intelligence established in terms of a constitution.
Have you not left out services after intelligence, or am I wrong?
I believe that's a typing error, Chair. You are correct. Yes.
Thank you.
All of these services are structured and regulated in terms of national legislation. Section 199(6) of the Constitution provides that no member of a security services may obey a manifestly illegal order. In terms of Section 199(7) of the Constitution, members of any security service must always act in accordance with the Constitution and the law, and may not act to either prejudice a political party's interest that is legitimate in terms of a Constitution, or further in a partisan manner any interest of a political party. Section 198 sets out the governing principles.
Before you move on, let's go back to 8, Section 1996. Who does that relate to? Ordinarily, one would think that it relates to orders from a member of SAPS, a senior member to a junior member. Does it go beyond that or not?
Chair, it's my submission that it relates to any member, irrespective of where the order comes from. But if it is in the execution of his powers as a police official, it will mean that he cannot obey a manifestly illegal order.
Oh, thank you. What I want to understand is whether this would go beyond SAPS. For example, an order / instruction from outside of SAPS. I'm not pushing you to say yes. I just want to understand your interpretation of the section. Does it relate? Is it an intra-SAPS provision?
My understanding or my interpretation will be if the person is to exercise a policing power, then it means he cannot exercise, irrespective of whether that instruction comes from a commander or whether it comes from anybody else who is capable of giving orders to that member.
So I think perhaps just to be clear, your response is it is not necessarily applicable only intra-SAPS.
That's correct.
But it would apply even if an instruction emanates from outside.
Yes.
But it is expected to be executed by a SAPS official as a member of the service, as contemplated in Section 1996.
Yes.
Okay. Thanks. Then if you can proceed in paragraph 9, you deal with Section 198.
Section 198 sets out the governing principles of national security. The police as a national security entity must reflect the resolve of South Africans to live as equals in peace and harmony, free from fear or want. Must pursue national security in compliance with the law, including international law, and must remain subject to the authority of Parliament and the National Executive.
Okay. Then your next subtopic is the constitutional mandate of SAPS, which you cover from paragraphs 10 to 17. If I can just ask you to please deal with those, commencing from paragraph 10.
Okay. Section 205 to 208 of the Constitution sets out the constitutional mandate of the police, the control of the police, and the assigned political responsibility of the police service. Section 205 starts off with the objects of the service, and it relates specifically to prevent, combat, and investigate crime, to maintain public order, to protect and secure the inhabitants of a country and their property, and to uphold and enforce the law.
Yes.
205.2.
Sorry. Before that, we know that this section you deal with it later, but it is going to be important on the aspects that you deal with in relation to the minister's instruction or directive that he issued on the 31st of December 2024. Is that correct?
That is correct.
Okay. All right, we'll deal with that when we get to that section of your statement. If you can proceed with 11.2.
National legislation must establish the powers and functions of the police service and must enable the police service to discharge its responsibilities effectively, taking into account the requirement of the provinces. The SAPS must be structured to function at national, provincial, and where appropriate local spheres of government. In terms of Section 206 of the Constitution, the Minister of Police must determine national policing policy. This he does after consulting all the provincial governments and taking into account the provincial needs and priorities of the provinces as determined by their respective executives. Section 206.2 provides that the national policing policy may make provision for different policies in respect of different provinces, after taking into account the policing needs and priorities of the respective provinces. Each province is entitled to monitor police conduct within its area of jurisdiction, oversee the effectiveness of visible policing, and liaise with the minister in respect to crime and policing of the provinces. Section 206.8 of the Constitution prescribes that a committee made up of a Minister of Police and members of the executive councils responsible for policing must be established to ensure effective coordination of the police service and effective cooperation amongst the different spheres of government. This committee is commonly referred to as MINMEC, meaning Minister of Police and MECs. The National Commissioner, appointed by the President in terms of Section 207, exercises control over and manages the police service in accordance with the national policing policy and directions of the Minister of Police.
And again, if I can just indicate here, just to highlight where you are going. This is also going to be a relevant provision when you deal with that instruction.
That is correct.
Yeah. Yes, if I can then ask you to proceed from paragraph 15.
Provincial commissioners are appointed by the National Commissioner with the concurrence of a provincial executive in terms of Section 207.3 of the Constitution. The provincial commissioners are responsible for policing within their respective provinces as prescribed by legislation and are subject to the power of control and management of the National Commissioner. The Intelligence Division of the Police is part of the National Intelligence Structures Act as determined, or as is part of the National Intelligence Structures as determined and governed by the National Strategic Intelligence Act.
Yes,
and maybe I can just pause here and indicate that in terms of the National Strategic Intelligence Act, there are specific powers assigned to the commissioner or the head of a division of crime intelligence. So there are certain operational powers that specific individual, which in this case is Lieutenant General Dumisani Kumalu, is empowered to exercise. The powers of crime intelligence of a police in respect of the National Strategic Intelligence Act relate specifically to the gathering and analysis of intelligence for the furtherance of the objects of a police as set out in Section 205(3), in other words, to prevent, combat and investigate crime, uphold and enforce the law. To furthermore take steps to address counterintelligence in the police. This also includes security vetting and security screening of police officials. That is a specific power assigned to the Division Crime Intelligence in terms of the National Strategic Intelligence Act. And then furthermore to report on the intelligence gathered by the police to NICOC. NICOC is the National Intelligence Coordinating Committee. Where all three intelligence services are represented. In other words, SSA, military intelligence of the defense, as well as crime intelligence of the police service.
Perhaps if I can just interrupt you there before you deal with the summary that you pulled together in paragraph 17. We know that the National Commissioner, as part of his evidence, dealt with the two requests that he defined as three areas of contestation, where dockets that relate to intelligence were sought, or at least were requested to be transferred to Lieutenant General Sibia, and he told the Commission that first that request was made by General Sibia himself, and then later also when the minister took office, or at least some time thereafter, he also made a similar request. So this is a very important aspect in respect of areas that the Commission will have to determine as part of its terms of reference.
That's correct.
Am I correct?
Sir. Yes, that is correct.
That's correct. Right. And then you conclude in paragraph 17 by saying, in sum, the Constitution establishes a single police service. This concept creates one unified and standardized police service across the Republic under the leadership and command of the National Commissioner. And we know that this references Section 207(1) of the Constitution.
That is correct.
Then the next topic that you deal with is the South African Police Service Act, the SAPS Act. And you start from paragraph 18, and if I can ask you to commence from there.
The Police Act is the legislation contemplated in Section 199 of the Constitution that provides for national legislation must regulate the security services. In terms of a preamble of the Police Act, provision is made for the establishment, organisation, regulation and control of the police. It determines the terms of office of commissioners, the National Commissioner and Provincial Commissioners in Section 7, the recruitment and appointment procedures of members in Section 28. It also sets out the powers, duties and functions of respective functionaries and members in Sections 11 to 15. It provides for the authority to issue national instructions and orders in terms of Section 25. And it provides for disciplinary proceedings in terms of Section 40.
Then you next deal with the key SAPS role players. And the first key role player there is the Minister of Police. If I can ask you to proceed from paragraph 20 and just note the date there that needs to be corrected when you deal with that paragraph.
Mr. Senzo Mchunu was sworn in as the Minister of Police on the 3rd of July 2024. The typing error, the glaring typing error should be excused. And this is important because in terms of Section 95 of the Constitution, before a minister begins his tenure or begins to perform his functions, he must be sworn in. So that means once he's been sworn in, he is the Minister of Police. And it means that the term of office of Minister Mchunu started on the 3rd of July last year. He swears faithfulness to the Republic and obedience to the Constitution. On the 13th of July this year, Minister Nkunu was placed on leave of absence with immediate effect, and the President appointed Professor Feroz Kachalia as the Acting Minister of Police in terms of Section 91(3)(c) of the Constitution. The powers and functions of a Minister of Police in South Africa are primarily defined by the Constitution as discussed above and in terms of the Police Act. The Minister's role is to provide political oversight and to determine national policing policy, while operational control of a police service is vested in the National Commissioner. The Minister's key powers and functions involve the following. The Minister is responsible to formulate national policing policy in consultation with the provincial governments. This ensures an overall strategic direction of a police. This ensures that the overall strategic direction of a police service is aligned to national priorities in accordance with Section 206 of the Constitution. And in this regard, it should be noted that the Civilian Secretariat for Police Service has drafted various policy documents for approval by the Minister. It includes, for example, a policy on the reduction of barriers in the reporting of sexual offences and domestic violence. This policy aims, inter alia, to strengthen efforts to prevent and deter sexual offences and domestic violence by broadening and deepening the collection of information about such crimes, and to increase the access of victims to justice by reducing barriers to the reporting of sexual offences and domestic violence. A policy, once approved by the Minister, will require the National Commissioner to take steps for implementation and operationalisation. It should further be noted that the national policing policy, as envisaged in Section 207(2), was only approved in Parliament, in Cabinet in July of this year.
Now, can I ask you,
General, please pause there for a moment.
Okay.
The policies you refer to in paragraph 22.1, do you have sight of them before they go to the Minister for approval? What happens after the Civilian Secretariat has drafted those policies?
Part of the drafting process involves consultation. So even in the deliberations of a policy, the police will be roped in, so that we also deal with policing aspects, because it's no use to issue a policy that's not implementable and practical for the police service. So once the Civilian Secretariat has completed the draft document, it will be submitted to the Minister for his approval. Once it has been approved, it will be submitted to the National Commissioner with an official letter indicating that this has now been approved, and the implementation plans should be drafted to ensure the effective implementation of a policy.
In the last sentence of paragraph 22.1, you indicate that it should be noted that the national policing policy was only approved by Cabinet in July 2025. Can I please ask you to indicate what was the position in respect of the national policing policy before that date? Was there one in existence?
No, this is the first national policing policy that was approved since the interception of the Constitution. There were strategies previously, for example, the crime prevention strategy of 1996, but this is the first national policing policy that was approved and is currently being implemented.
But I suppose the Commission will hear more about the instruction that was then given on the 31st of December 2024 under the guise of a policy direction.
Yes. Chair, if I maybe can just, for the benefit of the Commission, just indicate that the national policing policy, the one that was approved in July, indicates 4 policy areas, and it's high-level areas. It relates, first of all, to effective policing. The second area, and there's a number of recommendations, but it just indicates the strategic level of a document. The second one relates to service delivery. The third one relates to community involvement and the need to have participation of a community in respect of matters relating to police. And the fourth one deals with ethical and strong leadership in the department. So those are the four pillars or policy areas specifically addressed in the national policing policy.
Yes.
What exactly does service delivery deal with or relate to?
There's a number of issues. For example, the treatment of complainants and the need to consider their privacy and to make sure that there's feedback given to a complainant once a case has been reported. It also deals with effectiveness in the gathering of evidence and the analysis of evidence during an investigation. So it basically deals with the delivery of policing services, whether it relates to crime prevention and our engagement with schools and other entities in respect of crime prevention, or whether it deals with the effectiveness of detectives and the manner in which investigations are conducted, including matters such as the analysis of forensic services, the DNA, the ballistics, and how the services in that regard can be addressed to ensure improvement and promotion of effective policing.
Thank you, Mr. Mdau. General, in the absence of national policing policy, which you say was approved by Cabinet only now in 2025, what has guided the police in the everyday operations or work that they do?
Keep in mind, Commissioner, that this relates specifically to the role of a minister. And certain policies, such as the one on the reporting of or the removing of barriers in the reporting of domestic violence and sexual offences, was a policy. It was simply not the national police policy or policing policy. And there's been other policies as well as the white papers on safety and security and the white paper on policing that were approved in 2016. But apart from that, our internal directives relate to national instructions, circulars, SOPs that are approved by the National Commissioner, and in the case of SOPs by the relevant divisional commissioner, to ensure effective policing and also to address policing needs. But those are the internal policies of the police to deal with policing matters.
You said somewhere in your response that there were other policies as well. I hope I heard you correctly.
That is correct.
What were those other policies?
As I indicated, there was a crime prevention strategy of 1996. That was a strategy issued by the Minister of Police. There's other policies relating to the use of force by the Minister that was prepared by the Civilian Secretariat, and also policies relating to community policing structures. So they were policies, but relating specifically to a aspect or a topic. The national policing policy cuts across policing in a more general and generic manner.
The one about strategic something, what exactly was that one about?
Sorry, Chair, I didn't get the first part.
The title or name of one of those has strategic in it. So I'm asking what that one addressed or addresses.
It was the crime prevention strategy. So it wasn't called a policy, it was a strategy. But it related to policy and direction in respect of crime prevention matters.
And would that not relate to the area of function of the PKTT? Because sitting where I am, I consider that to have everything to do with crime prevention, or is it about detection only?
The PKTT is an operational unit dealing with the investigation of crime. So the ripple effect will be to prevent crime once a perpetrator has been arrested and weapons have been seized. In other words, to prevent the further commission of crime. But their primarily responsibility is to investigate and resolve crimes that have already been reported to the police.
Or perhaps more directly then, would this policy that you and I are discussing not be applicable at all to the area of function of the PKTT?
Not really, Chair. It relates more to what we can call uniform police officials. In other words, the frontline services of policing.
Thank you. Is it not best, I do not know how thick those documents are, but is it not best perhaps that we should have sight of these policies?
No problem. We can make it available to the evidence leader.
Thank you. Thank you.
General, if the crime prevention strategy, you say in 1996, now we've had evidence that crime over time, criminal conduct over time has taken different shapes. Now we're speaking of syndicates, now we're talking about illegal mining and different sorts of crimes. On the face of it, and unless you say over time since 1996, there's a revision of the strategy to deal with new things, new forms of criminal conduct. On the face of it, a 1996 strategy, if it remained that, it doesn't seem like it responds to new ways of crime. What mechanism has been in place or is in place to deal with the new manifestations of different forms of crime?
Commissioner, I agree.
What has brought us here, for example,
Yes,
we speak
yes.
about criminal syndicates.
Yes, I completely agree with you. If we consider the world that we lived in 1996 in comparison to 2025, very little has stayed the same, and the same applies in respect of crime. Crime is a ever evolving scourge. And even the priorities, as you mentioned, illegal mining, even cyber crimes, were things that nobody contemplated in the era pre-2000. What we in the police are doing is there's numerous regulatory frameworks that we have. For example, national instructions, and national instructions will deal with general matters. For example, we have national instructions relating specifically to legislation, such as the domestic violence national instruction on children in conflict with the law to address the police's responsibilities in terms of the Child Justice Act, instructions on sexual offences dealing with the Criminal Law and Related Matters Amendment Act, and police procedures. So they are based on legislation, but it also addresses the internal processes. In other words, what official forms will be utilized? What are the time frames that we require police officials to attend to certain matters? What are the reporting mechanisms included in the police? Then apart from that, we've got national instructions on operational matters, such as case management. In other words, when a case is reported, what are the time frames? What happens to the docket when it's opened? How do you complete the docket? How do you update the system with events as they unfold in your investigation? In addition to that, we've got SOPs. For example, standing operating procedures are not issued by the National Commissioner. National instructions are. If I can just park SOPs for a moment, also what we have in the police is the Constitutional Court makes a ruling today that renders a specific provision relating to policing unconstitutional, which means there must be immediate action from the police's side to ensure that police officials take note and immediately implement the ruling of the court. On matters relating to cannabis, for example. So in that regard, there's no time for a national instruction because that's quite a comprehensive process. And we will deal with amendments in terms of court rulings by means of a circular. It's a shorter process. It's still approved by the National Commissioner, so it's an instruction from the National Commissioner, and every police official has to comply with that instruction. Then when we get to provincial commissioners, they can issue provincial orders and instructions specifically relating to their province, as long as it is not in contravention with a national instruction or an instruction by the National Commissioner. Then we've got SOPs. SOPs are more action steps. They can be supported or they can be in support of a national instruction dealing with more nitty-gritties on a specific aspect. For example, in visible policing, there's SOPs relating to firearms, specific the issuing of permits, dealing with firearms in deceased estates and things like that. That's supported by the Firearms Control Act. And then we also have in our operational structures, such as the NAT joints, operational instructions that can be issued. And specifically by in the NAT joints, we have priority committees. For example, a priority committee dealing with illegal mining. And that that NAT joints will issue NAT joints instructions. And that is coordinated. The NAT joints is chaired by the Deputy National Commissioner responsible for policing, Lieutenant General Musikidi, and co-chaired by the SSA and the Defence. So NAT joints instructions will be instructions that coordinate the operations between those departments. In other words, it's not only an instruction issued by the police for other departments, but it's signed by the co-chairs as well to ensure that it cuts across different departments to deal with specific aspects. For example, the illegal mining. Even during COVID, there were a number of NAT joints instructions issued to deal with COVID during that time. So there's different levels of instructions that may be issued, and it doesn't depend on the directives of the minister, because after all, the police has to operate continuously and deal with emerging threats and trends in policing, and we have to make a plan on how to deal with them.
Just for your comment, because further on you do deal with deficiencies and you will be making suggestions. The crime prevention strategy 1996, as you, from your experience and as you sit there, you consider it continues to remain adequate, or in the light of this just immediate past discussion that we've had now, does it remain adequate and relevant? Is it something that does require revision, reconsideration? What's your comment on that? And I ask the question without having any insight into what that strategy is and, in fact, what it deals with.
Commissioner, it's definitely required to be updated in view of current policing threats and challenges. But I do believe that the national policing policy addresses a number of issues that should have been updated in the meantime. So in that regard, it's not a document that should be seen in isolation. It deals with directives and policies issued by the minister.
Thank you, Commissioner Baloyi. Proceeding to still deal with the minister's key powers and functions, if I can ask you to proceed from paragraph 22.2.
The minister is the cabinet member responsible for policing and oversees the Department of Police. The National Commissioner reports directly to the minister in terms of Section 207 of the Constitution. The minister also has the authority to make regulations on a wide range of matters to ensure the proper implementation and administration of the Police Act. And this is provided for in Section 24 of the Police Act. The minister has, for example, issued regulations on matters such as discipline, employment, municipal police service, and reservist, just to mention a few. In addition, several key entities report to the minister. Their functions are regulated by separate legislation, but the minister provides overall strategic direction and oversight. These departments and entities are as follows. The Civilian Secretariat for Police Service, they are
Sorry, that's CSPS.
CSPS, yes.
Okay.
They conduct civilian oversight of the police and provides policy and strategic support to the minister. They are also responsible to give strategic advice to the minister in respect of the development and implementation of policies. It also monitors the performance and compliance of the police with policy directives and monitors the performance of the police service and regularly assess the extent to which the police service has adequate policies and effective systems, and they can make recommendations for corrective measures. The second department, apart from the Civilian Secretariat, is the Independent Police Investigative Directorate, commonly referred to as IPID. They are an independent body that investigates serious crime and misconduct committed by members of the police and municipal police service. The minister plays a role in the appointment and suspension of its leadership. So it's important, Chair, to take note that in the Ministry of Police, there are 3 departments: the South African Police Service, the Civilian Secretariat of Police, and the Independent Police Investigative Directorate. Separate departments, separate director generals, separate budgets. But in addition to the departments, there's also the entity reporting to the minister, and that is the Private Security Industry Regulatory Authority, CIRA. They are responsible to regulate private security industry under the minister's purview. Finally, in respect of cooperative governance at provincial level, the minister must consult with provincial governments when developing national policing policy to take into account the specific policing needs and priorities of each province. And as I've indicated earlier, the minister chairs the MINMEC committee that consists of the minister and the members of the executive councils responsible for policing. This committee facilitates cooperation and coordination between the national and provincial spheres of government.
All right, can I just ask you, as you are about to deal with paragraph 26, you start that paragraph in your first sentence by stating that the need for clarity on the role of the minister has repeatedly been raised as a concern. So as you deal with that paragraph, if I can just ask you to perhaps give examples where this issue has arisen, because you say it arose repeatedly. So if you can please proceed to deal with paragraph 26, bearing that request in mind.
Okay. The need to clarify the role of the minister has repeatedly been raised as a concern. It appears that there are different interpretations to words given or words contained in Section 207 of the Constitution that requires the National Commissioner to exercise control over and manage the police service in accordance with the national policing policy and the directions of the cabinet member responsible for policing. According to the Oxford Dictionary, policy refers to a course or principle of action adopted or proposed by government to achieve a particular goal, often outlined in written form or as a clear guideline for conduct. Chair, this relates specifically to the question whether the letter of the minister on the 31st of December 2024 was a direction given in terms of Section 207 and whether that fell within the purview of the minister to give that direction. So policy is clearly something that is proposed to further government goals, and it's often outlined in written form. And I believe in view of our discussion on the national policing policy, we all have a better idea of what it entails and also the strategic level of matters that are addressed in that policy as an indication of government's goals and aims.
But if I can just ask you to stop there, perhaps. You recall the National Commissioner said he reached out to the President. The President said he'll talk to the Minister. And then in one of those meetings where this issue was discussed, the National Commissioner says the President is in agreement with the disbandment of
Yes.
the PKTT, and therefore, by extension, the President was in agreement with that instruction that was issued. Does that make any difference in relation to your definition as you've referred to as policy?
Government's policy does not only relate to the decision or view of a president and a minister, and this is even more pertinent in view of our current government of national unity. So it cannot be proposed that even if it was discussed with the president, it has now become government's policy or government's intention to dissolve the PKTT.
All right. I understand your answer. Please proceed. This appears
to be aligned to the requirement that the national policing policy requires consultation with provinces to ensure a course of action to achieve a particular goal, in this case to address policing needs and priorities. This is furthermore consistent with the policies already drafted and issued by the Minister of Police, which were written documents and aligned to government priorities, with the aim to provide medium to long-term strategic course of action. In contrast, a direction is identified in the Oxford Dictionary as a position towards which a person moves or points, and refers to guidance or supervision. A direction does not require to be in writing and may also include verbal instructions. It appears to be focused more on immediate or short-term action.
Just on that, General, was the disbandment instruction a direction as envisaged in Section 2072 of the Constitution? If not, why? I am aware that from paragraph 93 onwards, you do deal with the question whether the disbandment instruction was a policy or an operational matter. You do not deal, however, with the question of a direction. That is from 93 onwards. Hence my question.
Okay.
So was the instruction a direction or not? And why not?
Chair, clearly it was an instruction by the minister. It also contained the word, I believe repeatedly, direct. The question is, was it a lawful instruction or direction, in the sense that the minister have the power to direct or command the closure of a task team that was investigating crimes. And in my view, it did not have that authority, because it relates to the operations, investigating cases, and the operations of the police. In other words, the execution of the police's mandate in terms of Section 205(3). If we say the National Commissioner is responsible to manage and control the police service, that must be linked to manage and control the police service in the execution of its constitutional mandate. And the decision of a minister to close a political task team that was responsible for the investigation of crime, in my view, fell outside the mandate or authority of the minister.
So in short, what may be purporting to be a Section 2072 direction cannot be such a direction if it has strayed onto operational matters.
I agree with that submission, or with that explanation, Chair.
Well, if I can just come in, it's not even a question of agreeing. I think the chair is simply paraphrasing your statement and the proposition that you put.
Okay.
So
I confirm.
Yes. I think lest the chair be misunderstood to say
Thank you
put a particular
Mr.
suggestion.
Mutau.
Thank you, Chair.
Sorry, Mr. Mutau.
Yes.
General, two questions from me. One about directions. What would constitute a direction that does not offend, a direction from the minister that does not offend the constitutional structure?
Commissioner, in my view, especially if you consider public engagement, such as in BISOs, will be a place where the minister engage with the community. And if a minister, for example, during such an engagement with the community finds out that there's unhappiness, for example, in the Western Cape with gangsterism, and the minister tells the National Commissioner, you have to do something about gangsterism, that would be a direction. In my view, it will be a positive direction coming from the evaluation of complaints or engagements that the minister had, and this can be with the community or it can be with the politicians in the province. And that direction is based on what he was told by members of a community or members of the executive in the province, identifying a specific area of concern or where there's a problem, and simply telling the National Commissioner, you must do something about this, or attend to this, look into this. As I said, gangsterism, I believe, will be an example that all of us can identify with.
Okay, so not the how.
Not the how, no.
Okay.
And I would also be careful to say that the minister can close things. In other words, that can have an impact on policing. So if he makes a positive suggestion or a positive guidance to say, look, or what can you do about this? But to close something may have a ripple effect that is not something that is anticipated by a politician when that decision is taken, simply because he's not, he cannot be expected to be aware of all the intricacies of policing and how one decision can impact on a number of other aspects of policing.
And the second part, in your paragraph 26, that opening sentence where you say the need for clarity on the role of minister has repeatedly, with emphasis on repeatedly, been raised as a concern. This, I don't know if this is the intention that you sought to convey, but it suggests this is not a once-off, the case that we're dealing with now, or the facts that we're dealing with now. It's not a once-off thing. There's been concerns. If you like, systemic concerns about the role of the minister. Is that what you're seeking to convey there? And if you do, if that's what you're seeking to convey, what are the specifics?
Commissioner, to be honest with you, I think it was more within the context of the last couple of months that we've been consistently working and attending to the issue of the closing and the closing of the task team and the implications thereof. So there wasn't any strange intention to include the word. I think it's just something that is constantly part of our daily operations. And I believe the implications of that letter and the fact that we are sitting here today indicates the need or amplifies the need for clarity, not only for the benefit of the organization, but also for the benefit of the executive, to ensure that there's a clear line to stay away from in respect of both the National Commissioner and the Minister, but also for the organization as a whole.
Your answer suggests that until recently, the recent incidents with past ministers, there's not been the kind of concern about the roles of the minister.
Well, the role of a minister has previously been highlighted, not only in the police, but in the Africa report on the July 2021 unrest, and the fact that the report or the commission held that there was an overstep of boundaries in the roles of the ministers during the policing of or steps taken to address the unrest. So it's not something that is completely new, and it's also not something that's only been identified in the police. It has been identified in other commissions as well.
Thank you, Mr. Madoe. In your interactions with the commissioners, you indicated that your misgivings relate to the how part. Can I ask you to perhaps complete that by dealing with whether can a minister, even assuming that his letter constitute giving direction as contemplated by Section 207, could he competently direct the when aspect?
No,
As opposed to the how. In other words, when.
No, you cannot, because once again, it will have operational implications. The whole issue of the continuation of investigations. Let me give a very simple example. That court case that was supposed to be heard on the first working day in January, what should have been done with that case? Should the investigator have simply withdrawn and say, I'm not involved in this investigation anymore? If there was a bail application, should the investigator say, I'm no longer authorized to, as a member of the political task team, to attend to this matter so that there's no one in court to oppose or to assist the prosecutor in opposing bail? So the practical implications of that, in other words, the immediately and also the how, is definitely problematic, and it shouldn't be left to the executive in view of the implications that it will have on policing.
But surely that would depend on the nature of that which has to be done. I know something like acts of torture, for example, are addressed as a matter of law elsewhere. But if despite the existence of such law, the minister is of the view that torture is committed by the police, what would be wrong if the minister were to say, I am issuing this direction and I am saying this must stop immediately? I'm just giving that as one example to make the point that surely it would depend on what the direction is about. And you cannot, in a blanket manner, say that it can never be immediate when it's issuing from the minister.
Chair, I agree. But in your example, torture is already an offence. The minister cannot...
That's exactly why I preface what I say by saying, with torture, there's already law about it.
Yes.
I would imagine that, put it this way, one cannot discount the possibility that there may be any number of other examples that may require immediate action, which may not necessarily mean that that becomes unlawful purely because the minister says this must happen immediately. That's all I'm saying.
Yes, I agree. But even in those circumstances where an immediate action is required, the decision must be rational. And rational requires it must have a lawful basis, and also it cannot be arbitrary. And I believe
I'm very sorry to interrupt you. That's something else altogether. I'm just making the simple point that surely it should depend on the nature of the direction being given. Yes, of course, whether or not it's lawful, it would have to comply with the law, including the Constitution. You are touching on irrationality. That's something that would be unconstitutional in terms of the Constitution. But that doesn't address the debate you and I are having now, which is that surely it may depend on the nature of the direction, and depending on that nature, in certain instances, the minister can be able rationally and lawfully to say this must be done immediately, this must stop immediately. Surely you cannot discount those possibilities. Otherwise, I'm not taking away from your point, but I'm just saying that you should not make the point so categorically as to discount those possibilities.
Chair, I agree. Circumstances may dictate that immediate action is required.
Yes.
Thank you. Thank you, General.
Thank you.
Mr. Mtawi, just last one for me, just to make sure I understand. General, if the minister had said, and let's come specifically to the PKTT instruction, if the minister had said to the National Commissioner, I want the political killings, the political killings that are the focus of the PKTT to now no longer be a priority in the list of priorities, no longer be your priority. Here's a new priority that I want you to focus on. If that's what he had said about the PKTT, would that offend the separation of policy and operation? Would you complain if the minister had said that?
Chair, in taking the cue from Commissioner, in taking the cue from the chair, I believe there may be circumstances where that is required. However, I also want to be careful to say that will also be always the case. But I fully understand there may be circumstances. Let's say there's a huge explosion tonight and a city is completely obliterated. Then the minister may say, don't attend to this, immediately go there and attend to that matter in view of the urgency of the matter, to simplify your example. So that may in circumstances be required, but I am hesitant also to say that will always be the case. I think we need to consider the circumstances of a specific incident.
Thanks. And I think moving from that part, that there can never be a general blanket exclusion, that there may be circumstances where a minister may competently issue directives or give direction by way of policy. If I could then ask you to move from that point and continue with paragraph 28 of your statement.
While neither Chapter 11 of the Constitution nor the SAPS Act provides for clear guidance on the ambit or scope of a policy or directives that the minister may issue, it is important to note that Section 85 of the Constitution deals with the executive authority of the Republic. Section 85(2) provides that the President exercises the executive authority together with other members of Cabinet by implementing national legislation except where the Constitution or an Act of Parliament provides otherwise, by developing and implementing national policy, by coordinating the functions of state departments and administrations, by preparing and initiating legislation, and by performing any other executive function provided for in the Constitution or national legislation. Section 92 of the Constitution provides that members of the Cabinet are accountable collectively and individually to Parliament for the exercise of their powers and the performance of their functions, and must act in accordance with the Constitution and provide Parliament with full and regular reports concerning matters under their control.
And then you proceed in paragraph 31 to conclude by providing your views subject to the qualification that you stipulate therein. If I can just ask you to deal with that.
In my view, which I offer purely for purposes of assistance, while I note that the issue relating to the proper implementation is reserved for the commissioners.
Interpretation.
Relating to the proper interpretation is reserved for the commissioners. The role of a minister, according to me, is therefore to provide national direction on a strategic level in accordance with government policy.
And the next key role player within SAPS that you deal with is the National Commissioner, and you commence with that from paragraph 32.
In March 2022, President Cyril Ramaphosa appointed Lieutenant General Fani Masimola as the National Commissioner of the Police.
And he thereby became a full general.
That is correct, sir. Section 11 of the Police Act details the responsibility.
Chair, I'm not sure whether can we use the English expression that he was then generalized with effect from that.
He was actually specialized by becoming.
Thank you. Yes, please proceed from paragraph 33.
Section 11 of the Police Service Act details the responsibilities and powers of a National Commissioner in managing and controlling the police service, including developing annual policing plans, determining the police's structure and numbering of posts, distributing its members, and maintaining training and operational institutions. The Police Act was amended by the South African Police Service Amendment Act in 2012, which clarified that the National Commissioner exercises control in accordance with the Constitution. I particularly highlight the following features as alluded to in the affidavit of a National Commissioner. And if I recall correctly, this was a matter raised by Commissioner Kumalu during the testimony of a National Commissioner. The National Commissioner holds the ultimate authority to control and manage the entire police service in accordance with the National Policing Policy and directives from the Minister of Police. And this is provided for in Section 207 of the Constitution. The National Commissioner ensures the police fulfills its constitutional mandate, which includes preventing, combating and investigating crime, maintaining public order, protecting people and their property, and upholding and enforcing the law.
General, in 34.1, when you say holds the ultimate authority to control and manage the entire police service, would that include the deputy national commissioners?
Yes, indeed, sir.
And when you deal with this evidence, can you also deal with their role as well? Because I see that after this section, you go to the provincial commissioners, but you don't say a lot about the deputies.
Okay.
And that is important in the context of the allegations made against General Sibia.
Okay.
And what authority he had to do certain things.
Okay. Commissioner, do you want me to deal with it now, or can I go through the key responsibilities?
You can go through them and then deal with it afterwards.
Okay. The National Commissioner is also, yes, I dealt with the constitutional mandate, strategic leadership. The National Commissioner is responsible to maintain an impartial, accountable, transparent and efficient police service in accordance with Section 25 of the Police Act. The recruitment, appointment, promotion, transfer and discipline of employees of the police service, including the appointment of provincial commissioners. And these matters are addressed in Chapter 9 of the Police Act, Section 207(3) of the Constitution on the appointment of provincial commissioners, Section 8 of the Police Act on the loss of confidence in a provincial commissioner, as well as in the South African Police Service discipline regulations, dealing with discipline matters of employees of the SAPS, except where specific provision is otherwise made in the Police Act, and Chapter 4 of the South African Police Service employment regulations.
Yes.
The National Commissioner is also responsible to ensure the provision of vital services such as crime intelligence, criminal records, crime statistics, and forensic laboratory services. This is contained in Section 218 of the Constitution of South Africa, the interim Constitution of 1993, and that provision has been retained in accordance with Item 24 of Schedule 6 of the 96 Constitution, the transitional arrangements.
And you've headed that operational support.
Yes.
Please read your headings as well.
Sorry, Chair.
I'm saying you did not read under 34.5. You did not read operational support, which is I don't know whether
The
you
lead.
call it the lead.
Yeah, the lead.
Yes, the lead to what you read.
Okay.
For the record, I think we do need that. Yeah.
Okay.
Like for instance,
apologies.
34.3 strategic leadership, and then
Okay, my
34.4 personnel management, and then you go into what you have and so on.
Can I continue from 34.6 with the correct?
Yes, please.
Okay.
Yes.
The National Commissioner is responsible for internal security, the maintenance of internal security of a nation in accordance with Section 2181C of the Interim Constitution, as well as international cooperation, international police liaison to facilitate cooperation and information exchange in accordance with Section 2181E of the Interim Constitution. The National Commissioner reports, its reporting structure relates to the direct reporting to the Minister of Police as the executive authority responsible for policing in terms of Section 206 of the Constitution, and the President as the authority who appoints the National Commissioner in accordance with Section 207 of the Constitution. In this regard, it should also be mentioned that the employment contract of a National Commissioner is concluded with the President in terms of the police employment regulations, and the President is responsible to deal with the loss of confidence in the National Commissioner in accordance with Section 8 of the Police Act. The National Commissioner also accounts to various institutions such as Parliament in accordance with Section 55(2) of the Constitution, and various other legislative oversight bodies, including Chapter 9 institutions, in accordance with their respective mandates as set out in legislation.
Yes, then can I request from paragraph 35, you say, in addition, I believe it will be prudent to highlight certain specific powers of the National Commissioner. If you could deal with 35.1 until 35.6, and perhaps thereafter address the question that is raised by Commissioner Khumalo, that of the Deputy National Commissioners.
Okay.
Before you deal with your concluding 2 paragraphs thereafter. Please proceed from 35.1, strategic planning.
Thank you, Chair. Strategic planning, the National Commissioner develops a plan at the end of each financial year outlining policing priorities and objectives for the following year. And this is provided for in Section 11(2)(a) of the Police Act. In addition, the National Commissioner is responsible to structure the service. He determines the fixed establishment of the police and the number and grading of posts within the organization, as provided for in Section 11(2)(b) of the Police Act. The allocation or distribution of resources is another responsibility, and he decides on the distribution of the services numerical strength after consultation with the board. This refers to the Board of Commissioners as contemplated in Section 10 of the Police Act. Organizational setup, the National Commissioner organizes and reorganizes the police service at national level into various components, units and groups. For example, the National Commissioner can decide to organize and arrange certain divisions together. Like currently we have one division called Visible Policing and Operations, and it used to be Visible Policing and Operational Policing separately. So we can arrange and rearrange. And this also means in respect of crime intelligence, the National Commissioner can decide how he wants crime intelligence to be structured as part of the broader structure on national level. The National Commissioner is also responsible for institutional development. He establishes and maintains training institutions for the training of students, in other words, new recruits, and members, in other words, in-service training of existing members. And this is authorized in terms of Section 11(2)(e) of the Police Act. Then finally, the maintenance of institutions. The National Commissioner establishes and maintains institutions necessary for the service's overall management and maintenance, such as bureaus, depots, workshops, and other facilities.
Then if I could ask you to pause there. If you go to page 20 of your statement, you provide a pictorial depiction of the top management structure within SAPS, and part of the positions that you depict therein relate to the Deputy National Commissioners. If I could then ask you by way of interposing your evidence to deal with the Deputy National Commissioners, and what do they do and what are they responsible for?
Okay. The Deputy National Commissioners, there are currently 3 Deputy National Commissioners. They are in terms of Regulation 8 of the South African Police Regulations in order of precedent directly below the National Commissioner. The organisation currently provides for a Deputy National Commissioner responsible for policing. In general terms, that means police officials that wear uniform. That relates to General Mosekiri's responsibility. That would, for example, be visible policing. It will be frontline police officials who work at police stations, attend to complaints. It will also be border policing units. In other words, wearing uniform. The Special Task Force, National Intervention Unit, and Public Order Policing. Typical police officials that you see in uniform reports through the relevant structures to the Deputy National Commissioner for Policing. Then the second Deputy National Commissioner is Crime Detection. That is General Sibiya's environment. That deals more with the investigating part. So that will be the detectives, forensic services, it will be protection and security services, as well as crime intelligence reporting to that Deputy National Commissioner. So General Mosekiri dealing with the crime prevention part, and General Sibiya with the investigating part of a mandate of the police. And then the third Deputy National Commissioner is responsible for support services, and that Deputy National Commissioner deals with the support environments. For example, human resource management, human resource development, which is the training part of the police, also responsible for legal services, supply chain, and technology management services. In other words, all the support services to enable the frontline police operational environments to execute their functions effectively.
Now, do the Deputy National Commissioners account to or report to the Minister?
No, the Deputy National Commissioners report to the National Commissioner, and the National Commissioner reports, as the head of department, reports to the Minister.
Can the Deputy National Commissioners say, once a Minister has issued a directive, we are obliged to A, comply with it, B, implement it, notwithstanding what the National Commissioner says?
No, the Deputy National Commissioner does not have that power. And I am reminding you, Commissioner, that Section 199(6) of the Constitution says no member of the security services may comply with a manifestly illegal order. So the fact that it came from the Minister and it didn't fall within the purview of a Minister to give that order is already problematic. The correct approach would have been to report it to the National Commissioner and to say, I've received this order from the Minister and I'm reporting it to you to give direction on how to deal with the matter.
You do deal with this issue later on in your statement when you deal with bypassing.
That is correct,
yes,
sir.
If I could just take you back to your statement. Let's proceed from page 16, paragraphs 36 and 37.
At this juncture, I pause to note that clear constitutional distinction exists between the political responsibility of a minister and the operational control of a national commissioner. The minister focuses on policy, governance, and political accountability, whereas the national commissioner controls and manages the day-to-day operations of a police service in accordance with the minister's policy directives. This structure...
Sorry, General. I may be mistaken. I think you are using the term policy directives for the first time. Perhaps Advocate Seagulls Ngube could help us with the word search, control, find, and see if it does appear before now. But let me continue so long. by directives, are you referring to the same thing as directions, which is the word referred to in section 2072, or is your idea of directives something different?
Chair, my idea is, as I explained the directives earlier in my testimony.
I'm asking a direct question. Is that the same thing as a section 2072 direction, or is it something different?
That is the same thing in my understanding, yes.
All right. Now, you seem to collapse what appear to be two concepts, collapse into one, what appear to be two concepts in section 2072. Section 2072 refers to policy and directions. The very fact that the Constitution puts them like that suggests that they are separate concepts. I do not know, perhaps through an interpretative exercise, one could say there isn't really a difference. I don't know. But the Constitution says policy and directions, and you've suddenly collapsed them into one, policy directions. In fact, you simply use policy now as an adjective, qualifying the noun directions, so that what for you appears to be the most important concept is directions.
Yeah.
So policy is merely adjectival, whereas the two appear to be two separate concepts. Do you want to please comment on that?
Chair, I concede. You are correct. The policies, as I explained, are more long-term written documents. It gives the government's goal to achieve certain objectives, albeit in the national policing policy, or the example that I utilized to remove barriers in the reporting of certain offences, and it aims the implementation by the police of long-term goals. These are not things that can be achieved overnight, but it is constant goals that should be entrenched in the police, in its operations, working towards that goal and ultimately achieving it. That would be my understanding of policy. Whereas directions are more short-term, immediate action. As I indicated, it can be written or verbal. What are you doing about gangsterism? I need a report, or I need you to do something about this. And in that regard, my statement may unnecessarily have caused confusion, for which I apologize.
No problem at all, General. I've actually also been exercising my mind over what these mean. I know General Masemula did give his interpretation. You have given your interpretation as well. And when you were engaged by my colleague, Commissioner Malloy, and you gave an example of what you understand to be a direction as envisaged in section 2072. I was interrogating within my mind the question whether, for example, the example you gave cannot actually also be policy. For example, if the minister says we should no longer prioritize such a crime, or we must prioritize such a crime, it's very difficult for me to say that's not policy. It's only a direction. It seems to me it may actually be both policy and a direction. I'm just stating that to say that this is an issue that raises serious interpretation issues.
Yes.
I'll leave it at that. I won't ask you to comment. Thank you, Advocate Mutau.
Thank you, Chair. If we can just conclude by pulling 36 and 37 together.
Okay.
And then with the leave of the chair and the commissioners, it's almost tea time.
Chair, in conclusion, this structure is intended to ensure political accountability, but insulating the police operations from undue political interference. And I think that is ultimate, the goal of getting that line right, to ensure that there is accountability, but not interference in policing.
Thank you. Perhaps we should adjourn at this point and resume at 11:15. Let's adjourn.